Hello, all, and welcome to Institutional Racism in Legal Systems Part 3, Understanding the Impact of Race in Housing. My name is Caitlin Collins, and I am the LRS Coordinator with the Fayette County Bar Association. With us, we have Anthony Gray, Ed Dove, Art Crosby, and Professor Robert Schwemm. Just a couple of housekeeping things. The annual Bench and Bar has been rescheduled for October 20th and 21st. To register, just visit the Fayette County Bar Association website, and it's on our calendar. For this activity, please use the Q&A function at the bottom of the screen if you have a question. The chat typically goes a little fast, so if you would like to ask a question, please use the Q&A. The CLE sheet for this activity is also on the website if you need that as well. If you have any issues or questions, you can reach out to us. Lastly, I would like to thank everyone that made this series possible. It's been amazing, and I wish I were able to thank everyone, but just know that you are extremely appreciated. And now I will turn it over to Mr. Gray so we can get started.
Thank you, Caitlin. We are very excited to have a great panel today to discuss this very serious and unfortunately still relevant issue of discrimination in housing. So I will introduce our panelists. I'll start with Art Crosby. Art is the Executive Director of the Lexington Fair Housing Council. His primary responsibilities include initiating community outreach programs and overseeing legal staff and filing complaints. Art has taught for the National Business Institute and lectures on both landlord and tenant law. He's a member of the Kentucky Bar Association, State Bar of Georgia, and the Florida Bar. Art received his BS degree in journalism with honors from the University of Florida, and he earned his JD degree, magna cum laude, from the University of Georgia School of Law, where he was a member of the Georgia chapter of the Order of the Coif. Next, we have Edward Dove. Ed is a Lexington attorney with more than 30 years of experience practicing and protecting clients' rights and providing superior service. He works with the Human Rights Commission, and he's on his second term as a commission's attorney. When Ed is not working with the Human Rights Commission, he represents clients in education law, civil litigation, and criminal law. Ed owns his own practice, which is located in Lexington and serves the central and eastern Kentucky area. Lastly, we have Professor Robert Schwemm. Professor Schwemm is the Ashland Spears Distinguished Professor at the University of Kentucky College of Law. He began his fair housing career as an attorney with the Leadership Council for the Metropolitan Open Communities in Chicago in the 1970s. He has written and lectured extensively on fair housing law ever since. His work includes major treatises in the field, including housing discrimination, law, and litigation. And he has many articles that can be accessed online that he has authored. Professor Schwemm has been plaintiff's counsel in several landmark housing discrimination cases, including 3 in the U.S. Supreme Court. From 1986 to 1990, he was vice chair of the Kentucky Commission on Human Rights. And in 1991, he served as a special attorney and scholar in residence with the Civil Rights Division of the U.S. Department of Justice. So we're honored to have our 3 panelists today. So I am just going to kind of jump right in with some questions. I'll direct the first question to you, Art. There was a study in 2017 that found that there was a 30.1% disparity gap between Black and white ownership, with 41.8% of African Americans owning homes as opposed to 71.9% of whites owning homes. This gap, this 30.1% gap, is wider than it was when race-based discrimination was legal in some areas when it came to home buying. So how do you account for the disparity, this disparity in the gap between Black and white home ownership?
So, I mean, I think that's a pretty easy question. It's what sets out whether or not you have a home often is where your parents were. right? Whether your parents had a home, what opportunities you had, what opportunities were presented for you. And we just know historically, as we kind of lay out, and it's kind of, I'll do a question, and it's going to take us off a little bit, but just give me a second here. But I'll talk with my friends who are realtors, and they'll ask, how do you decide where to find a home? And they will list off what their clients are looking for about schools. They'll talk about access to communities, walkable areas, and then we'll talk about, why are there areas of town that are all Black? And the answer is usually, well, that's where people they want to be around people who are like them. And I think we get this idea that things are like that the home ownership's discrepancy is like that the segregation patterns are like that because they've just always been that way. And it's not true. That's not how it's always been. What happened is we've put in the government and the systems have put in very specific patterns, very specific laws, ordinances, covenants that created a system where one party, white individuals, had access to wealth building, white individuals had access to buying homes, generational wealth, and one did not. We kept that out of African Americans early on, either slaves or not slaves in Lexington, could not own property in the beginning. Even when they could own property, they weren't allowed to buy in every area, or they weren't allowed to get loans in every area. And to think that all that happened, even 150, 20 years ago doesn't still have an impact today would be crazy. That's basically what it is. You set up a system, and that system, you set up a system to create two areas, one for whites, one for Blacks, and then you can't be surprised when the result still is that way.
Very true.
Anthony, could I follow up just a little bit on that?
Sure.
I think Art's laid it out pretty well. I just want to mention a couple of things that reinforce what he said. Segregation in housing is something that Americans invented. It did not exist after the Civil War. It did not exist in the late 19th century. It was basically a creation of laws and policies during the Jim Crow era in the early part of the 20th century, particularly when the Great Migration of African Americans from the South occurred. And a classic example in law school is that the city of Louisville and many other cities, but the city of Louisville's case went all the way to the US Supreme Court, literally decreed that Blacks could not live by Louisville's zoning ordinance in neighborhoods that were occupied by whites. That was the law. And that was struck down, but immediately other people who had the same interests in white neighborhoods adopted racially restricted covenants. The Louisville law was struck down in 1917. Racially restricted covenants were not struck down until almost 1950. And you have measures during those periods of the degree of racial segregation. As I say, it didn't exist. All of us alive today can hardly believe that we could be in a country with integrated housing, but for many, many years, the nation did have integrated housing. It's only a 20th century invention, and there's a book that's about 3 years old now called The Color of Law by Richard Rothstein. It's recounts in detail what Art and I have mentioned. These various government policies, including as far as wealth building, the GI Bill had a lot of discriminatory functions in it, and the capacity to get home mortgage loans had a lot of discriminatory functions in it. And so you get this law in 1968, the Fair Housing Act, which is now 50-year plus. And as Art said, it doesn't immediately change anything. I'll mention one last story. About 25 years after the Fair Housing Act is passed, you mentioned in my introduction, Anthony, I worked for the Justice Department in the 90s. My boss there, who was in charge of enforcing the Fair Housing Law of the United States, was speaking to a group of visitors from South Africa, the newly liberated South Africa. They'd gone all over the country and they wanted to discover what the United States was like. And they ended up their tour with some officials in Washington, including this head civil rights official that I worked with. And here's what the question was in about 1992, I think. We've been all over your country. We've been in particular cities like Detroit and St. Louis and Chicago. So we understand that you in the United States have laws that mandate the separation of the races. I pause for emphasis. This is 25 years after the Fair Housing Act was enacted, and they're talking to a person who's spending his career trying to enforce non-discrimination in housing. And these people have gone around the country and they say, well, we know you have laws mandating the separation of races in housing. We used to have those kind of laws in South Africa. What we don't understand is how are you, as a law enforcement official, so effective in enforcing those segregation laws? What could my friend say? You know, that my job is to actually turn the corner on that. We have these measurements of how segregated the nation's metropolitan areas are, and we are making incremental progress. At the worst, about the time of the Fair Housing Act being passed, the measure was roughly 80 on a scale of 100. Extreme segregation. If 0 was salt and pepper integration and 100 was total segregation, most major American cities were around 80. Now we're to the point after 50 years where most American cities are between 65 and 70, and some of the Western cities are under 50. It's a very, very slow process, as Art mentioned.
Anthony, just to follow up on where Professor Schwemm was talking, from 1934 to 1962, the federal government put $120 billion into home ownership, right? That was what created this whole idea about taking out a 30-year loan. That's the thing that gave people access to be able to be a first-time home buyer incrementally and not just have to have all the money in advance. But of that $120 billion, less than 2% of it went to people who weren't white. And we know that that's what creates the generational wealth that one part that whites were able to pass down, and that's what they were able to get a home, build equity in it, send their kid to college, their kid gets a good job, their kid buys a home, and it continues. And we know on the other end where that money was not going in through what was termed redlining, because they would use red circles around maps and say these are not appraised as good investment opportunities. We're not going to put the $120 billion into those areas. And those areas became, boarded up public housing because the investment didn't go in.
So you kind of touched on a little bit about how, we have the Fair Housing Act and all of these, I guess, things procedurally on paper that are supposed to stop these discriminatory practices, but we still see evidence today that there are clear discriminatory practices when it comes to housing and home ownership. I wanted to talk, and maybe Ed, you can, I'll send this question to you. I mean, we still have individuals that are facing, racial discrimination when they're trying to, for example, get home loans for bank or apply for housing. Is there any protections in place for that, particularly regarding to the Fair Housing Act? And if not, does it need to be updated to provide legal protections for this type of?
No, I think Art is definitely the expert. Well, Professor Schwemm also on the Fair Housing Act. But since you directed it to me, at the Human Rights Commission, certainly we enforce the Fair Housing Act and the statute KRS 344-600. But yes, there are enforcements. The Fair Housing Act does prohibit a failure to provide opportunities to purchase housing based on race and the other, other protected classes. Finding that out, I think, and you guys jump in here. I think the biggest problem we have is in home mortgages as well as in leases is when people are turned down from receiving a loan or the opportunity to rent, they do not follow through, and so that issue never gets out to the commission or to the Fair Housing Council, and people just kind of give up. But the Fair Housing Act, and you guys may want to jump in more with more specifics, but the opportunity the denial of opportunity to purchase or to rent is a provision in the Fair Housing Act that would be enforced by the commission and also through a private action.
So I'll follow up real briefly, or maybe not briefly. Yes, there are protections. Yes, there are individual incidents of discrimination where a person says, I'm not going to loan to you because you're Black. I'm not going to rent to you because you're Black. We also know that there's systems in place that, so you have those intentional acts. You also have systems in place that the systems are based on discriminatory ideas, or just like, we're not going to sell you a home, or we're not going to provide housing services if this home's under 100,000, but we will for more expensive homes. And I think all those are issues, all those are cases that we fight, all those are things that should be addressed and need to be addressed. I think you could take all of those issues, fix everything. You could make it so there's no more intentional discrimination at all. And I don't think it would have that much of an impact on the world we live in. I think the legacy of what has been created in the past is so strong that you don't even have to do anything to keep it moving. You can make all the laws quote unquote fair from here on, and that impact will just continue. And I'll give you a brief example. We worked with the New Albany Housing Authority and talked with the executive director there. He came in it was about 5 or 6 years ago he came in. And at the point he took his job, there was 2 buildings. One was the tenants all would refer to as the white building, and one the tenants would refer to as the Black building, because the white building had all white tenants and the Black building had all Black tenants. And at this point, he's no longer discriminating. The New Albany Housing Authority in the past had created, through intention, a Black and white building to separate them out. That was no longer their intention. They were no longer trying to intentionally discriminate that way, but the tenants, everybody just referred to it as that. And if a Black individual came up on the list and they were up for the white area, they just chose not to do it because they knew that wasn't where they seemed welcome. So there didn't have to be any new laws in place. There didn't have to be any new intentional discrimination. The system had already set up a system where people just knew, and you couldn't fix it. I mean, that director wanted to try to integrate those 2 buildings, and he just didn't know how.
Well, I think the other thing is what I was trying to say, and probably wasn't very clear, is following up with Art, is that systems and statements, people, you don't go in and say, okay, we're denying you this loan because you're an African American or because you're an Asian. The subtle denials of housing opportunities people don't realize may be discriminatory, and you know, that's kind of scary. It gets back to an educational type issue that we need to be, people need to be more aware of their rights under the Fair Housing Act and under the Landlord Tenant Act to protect them from discriminatory practices.
I want to mention a couple of points that I think are hopeful, so that we don't leave the audience with the idea that we aren't making some progress and that it's impossible, no matter how hard we work, to improve this. One has to do with sales as opposed to rentals. I have watched the National Association of Realtors and individual realtors in Lexington over the years, and they have made real progress, in my judgment, in their attitude toward being non-discriminatory. If you look at the overall national statistics on fair housing complaints, a very, very small percentage involves sales complaints, less than 5%. Over 80% involve rentals. Now, it's easier to file a rental complaint, and it's easier, as Ed mentioned, to know you've been discriminated in rentals. But even in rentals, the way the law is set up, it's very difficult for somebody to stop their life if they're turned down for a rental apartment and file a lawsuit. If you're not promoted in employment, for example, you've got a job, it may not be the one you wanted, but you look at the person who is approved above you, and you might say, well, that's discrimination. That doesn't happen in housing. Ed mentioned it's very hard to figure out, even if you've been discriminated against. And I think slowly but surely, and slowly is the key word here, even the rental professionals are getting a little more attuned to it. The second thing I'd like to mention is the generational change. I'm saying my generation to the younger realtors and apartment managers and even people entering the housing market today. There is a much greater acceptance by all people, particularly whites, but by all people, of living in diverse areas and neighborhoods than there was when this law was passed. I remember when they were debating the Fair Housing Act in 1968, the opponents would say, well, you just can't legislate morality, or you can't legislate goodwill or something like that. My observation as a law professor is that that's 100% wrong. What we have is not that you would legislate morality or goodwill. People who are going to resist the law are going to resist the law, but for want of a better term, they die out and a new generation takes their place. And we have now lived for 52 years in this country with this as the policy of the United States, that is non-discrimination. And my view of, say, the average 30-year-old is that those folks are much more interested in just the classic example of, is it a nice neighborhood? Do the people take care of their houses? I don't care about the diversity. My generation is going to pass away, and in some ways that's a good thing. I had a realtor talk to me just yesterday about this issue, and I said, how many times in the last 20 years has a homeowner asked you to discriminate? And she said, never. And then she described the Lexington market as woke. Fortunately, I have a daughter-in-law who explained to me what woke meant about a month ago. Otherwise, I'd say, oh, you mean they get up from their nap and then they go out and look for housing? No, she says, it means that they are, I don't know, you can translate it better than me. My translation is they're with it, they're part of a modern generation. And she, you know, without naming specific neighborhoods, she said there are places in Lexington that are being gentrified, that people, young people wouldn't have moved into 20 years ago, that now they want to move into it. They don't want the big yards. They want to be close to downtown. Now, it takes time. It's very slow. It's somewhat frustrating. But I don't want to leave the audience with the idea that this is an impossible problem to address. It's very, very difficult. It's very, very ingrained in a lot of our thinking. But it is possible to change this. And another book that I put on the reading list is from 2 years ago called Moving to Integration. And as the title implies, the overall nation is moving toward a more integrated situation. And the book, though difficult to read because it's an academic book, has about 15 or 20 specific policy suggestions. Including how to get more affordable housing into a variety of neighborhoods. So there are some positives out there.
I'm going to push back on the positives. Sorry. So I agree, like, completely. The Lexington Board of Realtors does train. They are committed to fair housing. I think they're committed to making sure the realtors out there are saying the right thing and doing the right thing. I firmly believe that. We do regular trainings with them. And I think in terms of sales, I think most people, we do not have discrimination, at least overt discrimination is often in sales. Most people are motivated by the maximum amount of money in return they can get from the home. But we still do, there was a study in 2003 that the National Fair Housing Alliance did of 12 metropolitan areas of steering, basically. So a realtor would show people where they want it, a realtor showing you where you want to live, where are you interested in. And like I said, the realtors, for some population, we have this idea of, like, it's all about schools, it's all about transportation and in jobs. But we know in that study, 87% of the time, people were shown something different based on their race. If I'm Black, there's just going to be an assumption. There's a critical mass, in Lexington, we know there's a critical mass in Winburn. We know there's just a critical mass in Cardinal Valley of Hispanic. We just know, and that becomes this idea of, well, that's where you're going to be more comfortable living with people like you. And realtors subconsciously, or maybe not even the realtor, but the home buyer is going to think that is a more welcoming community for me, and is going to be more likely to find or look at housing where they know other people like them live. So we just know that type of thing still does. People are still steered to areas. And we also know that even in today's world, in today's politics, the idea of bringing affordable housing into the suburbs is a talking point. It's a talking point right now, and it probably will be a talking point for the next couple of years.
All true.
And we have a question. Cassie Carter is asking, can you discuss the effects of gentrification, positives and negatives? It has been said that gentrification can cause home prices to go up, continuing to push individuals out of home buying.
I'll take a start. Gentrification is going on in Lexington, and it's going on all over the country. I get calls almost weekly from Miami, Chicago, everywhere, where neighborhoods are being targeted. Targeted isn't really the right word because we're used to a market economy. I mean, the younger folks who want to live in a city, who are professionals, are moving into neighborhoods, and they are bidding up the prices. In some ways, in terms of the Fair Housing Act's goals, it's a good thing because it does lead to a greater integration racially. It also gives some clout to those neighborhoods that they never had before because they're people who have power and money who are going to insist that they have decent parks and decent schools. The other side of the coin is that there's no doubt that there are some very, very sad and individualized stories where people who had lived in the very same neighborhood for their whole lives, and maybe their parents' lives, all of a sudden find the rent so high that they're basically forced out. And usually they're forced out to a place that's just as segregated as the neighborhood was that they're talking about leaving, yet they don't have any ties or friends. There are government policies. Unfortunately, a lot of housing is local. So what's being done in Miami or Chicago or New York, a little bit might work, but it's hard to not admit that gentrification as an issue doesn't have real sad victim situations. So it's a mixed bag.
Right. The gentrification itself isn't the issue. It's the involuntary displacement that it usually brings with it. And even with the integration, which we do believe gentrification can have that positive impact, sometimes you lose that over time. Sometimes once the area becomes completely gentrified, you lose the integration you had. It shifts completely over into a white upper class. Once the, like you no longer have, not only does the rent go up, but you bring in, ice cream that's $4, you bring in restaurants that's $25 or $30 a meal. People just aren't able to use the amenities that come with it. We are not, as a community, committed to inclusive, diverse areas where we live. We believe in that. Once it changes, we believe in changing it all wholesale. So when we don't, and I don't know what good solutions are, but gentrification is a fair housing issue, and it's one we don't have great answers to.
There's another thing that Richard Rothstein, this fellow who wrote The Color of Law, wrote about Ferguson a couple of years ago. That's the St. Louis suburb that got so much in the news because of the killing. Ferguson was a black ghetto in 1968 when the Fair Housing Act was passed. But what the Fair Housing Act did, and this is a really sad irony, is it allowed the wealthy blacks in Ferguson to leave. And slowly but surely they did. There were doctors, there were lawyers, there were other kinds of professionals. And what you end up with, to the extent we still use the ghetto term, or at least an impacted area of poor and largely minority people now in the country, in every metropolitan area, is in some ways much more difficult to deal with because of the lack of role models, the lack of wealth, the lack of services that a pre-Fair Housing Act black community had. And the same is true with the kind of community that might become gentrified. I mean, the problems are partly race, substantially race-based historically, but they're also horribly involved with poverty. And it shouldn't have come as a surprise to anyone who thought seriously about this when COVID hit, that so many other negatives in life are associated with living in a poor and substantially impacted racially neighborhood. I mean, health issues, as Art sort of alluded to, the kind of food you have access to, the medical care you have access to. It's a very, very challenging problem. It's something that I think can be marginally improved, but very difficult. And we have to have national policies that recognize that a whole region is a housing market, not just individual narrow neighborhoods, and that each neighborhood has to take care of themselves.
I'd like to touch on COVID a little bit later. I'll come back to that because you mentioned COVID and there's some questions I want to ask about that. We've been talking a lot about the Fair Housing Act. So there was obviously the amendments to the Fair Housing Act in 1988 that established enforcement mechanisms for the Department of Housing and Urban Development and the Department of Justice. Do you feel like, for example, HUD is being held accountable for enforcing fair housing policies and bringing them to court when warranted? And if not, how can that be done? And then also in regards to HUD, I mean, how do they accept and investigate complaints of housing discrimination from the public? I'll throw that to you, Art.
Okay, and Ed, you can back up on some of this too. But again, so locally, if you have a complaint, the easiest way is either through contacting us as a representative through the Fair Housing Council, but it would go to the Human Rights Commission. The Human Rights Commission is the contract through HUD to do those investigations, and Ed serves as the attorney for them. So the commission takes the case, investigates it, makes a finding, probable cause, not probable cause, and then it can go to court for litigation. HUD has set up a system where people do have access to essentially free assistance, free legal assistance to help push their claim. And I think for the most part, you know, that Ed had mentioned earlier, there are some questions about whether or not people are aware of those rights, use those rights, but those rights are there. I think that part of the system does work about as well as we can get it right now. So in terms of that, HUD does, I think, what they need to do. That addresses, but the Fair Housing Act had two parts. One was the enforcement, the other was the affirmatively furthering fair housing, right? The idea of we've created this whole legacy, how do you deal with the legacy impacts? I think we are dealing with the current intentional acts. I don't know that we're doing anything to attack the legacy impacts.
Okay, Representative Commission, as Art alluded to, I think that obviously we get cases from the Fair Housing Council to investigate. Our cases are duly filed with HUD. HUD oversees our time limits of how, for example, if a complaint is filed, there is a 100-day period of time where we're supposed to investigate, make a decision. Certainly, we all know in the law, the 100 days usually comes and goes. But HUD has been pretty proactive in reviewing cases from the commission. They have sent cases back to the commission for further investigation, for further action. The enforcement, I feel, from HUD is about its best, kind of echoing Art, is under the circumstances we are now, is probably about the best we're going to get under this administration. I just want to talk about the enforcement here. If a complaint is filed with the commission and the commission determines a probable cause or that a Fair Housing Act violation has been committed, we will give the landlord an option of either maintaining the case at the commission for an administrative hearing, or they could elect to go into circuit court under our statute. Most landlords have elected to go into circuit court. Right now, the commission itself has 4 cases in circuit court, and we are litigating those just as any other civil action. I I think the enforcement also that a lot of landlords don't realize is that if a fair housing violation is proven, that there can be a civil penalty against the landlord or the realtor, which could amount up to $50,000. So it's a hammer here that they should realize that the statute takes these cases serious. The other side is a private action. A person who has felt that they have been a victim of discrimination under the Fair Housing Act or under our state statute can file an action, a direct action, without exhausting administrative remedies in Fayette Circuit Court. We have a couple, privately, I have a couple of those going right now. But I think the commission, our local commission, has been very aggressive in prosecuting fair housing cases. I can't say that with the state commission. They've gone through a turmoil, obviously, with the new director and all that. But I feel in Fayette County that, and I hope Art echoes this, we are very aggressive in protecting the rights of fair housing here in Fayette County.
I might follow up just a little bit on a point that Art made, which is consistent with everything Ed said. And by that, I mean, individual enforcement of the Fair Housing Act, I think, is okay. There was the second provision in the 1968 Act that is 52 years old that said, in addition to that, everyone who gets a federal grant from HUD must affirmatively further fair housing. Everybody of a local government nature gets a grant from HUD. Fayette County gets grants from HUD, Jefferson County gets grants from HUD, small counties and towns in Kentucky and everywhere in the world get. And by that, I don't mean that it's a fair housing grant. I mean, if you get a grant to improve your sewer system, you have to sign a pledge that we will use this money in a way that affirmatively furthers fair housing. HUD historically has done nothing to enforce that mandate. That is to say, they give out the money year after year after year after year, and they don't really press the local jurisdictions to do anything to get more active, so that there's some towns that don't have the kind of commission that we have in Lexington. The most active person historically with respect to this was President Nixon's HUD Secretary, George Romney, the father of the Senator Romney. But nobody, even up to and including the early Obama administration, did much for this. By the way, my light just went off, which is amusing to me because this fabulous new building we have is supposed to be a green building and preserve light, right? So when it senses no life in the office, which in my light system has just sensed no life in my office, it turns off. But there is life, there is life. And this particular provision was weakly enforced by Democrats and Republicans for decades and decades and decades. In the very 11th hour of the Obama administration, HUD tried to put some teeth into this law. And it was almost the first thing the Trump administration did, which is to rip those teeth out. And as Art mentioned in his remarks, this has become a political issue. The way President Trump mentions it now is that this was some kind of social experiment by the Obama administration to ruin the suburbs. Well, it wasn't a social experiment. The social experiment, as Art and I laid out earlier, was segregated housing. This was a way to try to slightly undo some of those provisions, and the people who passed the law in 1968 wanted it done. And this administration has made it virtually impossible. One possibility down the line, if you had an amendment to the Fair Housing Act, is you'd provide private enforcement for this, so you wouldn't rely entirely on HUD to take care of itself. And the last thing I'd say with respect to this administration, as opposed to prior Republican and Democratic administrations, they don't bring race cases under the Fair Housing Act. They bring disability cases, they bring sexual harassment cases. In the last week, the Justice Department under the Trump administration filed its second race discrimination case in 3.5 years. That's inconsistent with President Bush 1, President Bush 2, President Reagan. And you need the Justice Department to do the kind of things that Ed was talking about in sophisticated cases involving lending. An individual human being can't effectively prove lending discrimination. You got to get into the records of the bank. And that used to be the province of the Justice Department. I guess you'd still say it is. But it's been a policy of the current administration. So it's very discouraging. It puts all of the energy back on the individual victims. That's something I hope can change, but we'll see.
Well, the other thing Professor Schwemm, just follow. Art and I were, I guess it's been 3 or 4 years ago, involved with the community inn issue that was zoning and wanting to, remove the community inn, which was a shelter for the homeless population, a night shelter. And Art and I both argued with the city that one of our swords in the quiver was this further advancing affordable housing. I don't know if it got anywhere. I mean, because we would have had, but we did use that, and it basically worked. But I just want to say one more thing about the enforcement, since we did back, I can't remember what year it was, the first Fair Housing Act with Fayette Circuit Court, Elsie Speed versus, I can't remember, but I think the problem we have with enforcement is the knowledge of the judiciary also on what is required of the Fair Housing Act. I mean, a lot of our judges are familiar with landlord-tenant. They may have risen up from district court or whatever. But when you go in to talk about affordable housing, about quiet enjoyment of goods and services and equality in services, sometimes you're looking at the judges and their eyes are like, they've seen a deer in the headlight. They really don't know what you're referring to. And I mean, that's frustrating. That's totally frustrating. So I don't know the answer to that, except we need to get more housing cases into the circuit courts so they can understand the requirements of the Fair Housing Act.
This is something in terms of both the judiciary and the public's attitude towards civil rights that has always put housing last. If you think of the 1960s and the civil rights laws, the 64 law was about employment and public accommodations. And then the 65 law was about voting rights. And it wasn't until 3 or 4 years later that the Fair Housing Act got passed. And housing has always been last, for want of a better way of putting it. Everybody seems to know that there are public accommodation civil rights laws, and everybody seems to know that there are employment discrimination civil rights laws. Not that they're always totally honored, but everybody knows it, right? Right. It comes as no surprise to a judge that there is a Voting Rights Act or a employment discrimination or a hotel discrimination law. But I agree with you. And one of the things that has happened, and this I think is a positive thing, in the last 10 years, for the first time in my career, is that people around the country, and maybe ultimately judges even, are beginning to understand that housing is everything. That is to say, housing is the quality of your education. Housing is the quality of your health. Housing is the quality of your air and your neighborhood services and what kind of grocery stores are there. There are incredible studies. A researcher about 4 years ago by the name of Raj Chetty, a very significant nationally recognized researcher, studied children in different neighborhoods that were essentially side by side in the Chicago and other areas. And you see the difference in life expectancy and the difference in other kinds of outcomes of just being a mile away. And it boils down to, we just have to get housing and not just the theory of housing, but integrated housing and diverse housing and housing opportunities all over the place. We just have to crack that particular nut, because everything is now seen to turn on that. Now I'm going to go turn my light on, not to pay attention, but I am going to take about a 10-second break.
I wanted, since I believe Ed had mentioned the judiciary and courts. So I wanted to, and whoever would like to take this question, to just discuss the differences in how the court looks at desperate treatment cases versus desperate impact cases. It's especially in light of the Texas Department of Housing case in 2015. And what is the strategy of litigating fair housing cases moving forward?
I'll take a beginning shot and then let Art and Ed jump in. I mean, again, it's another example of how housing has been behind employment law. A number of you probably out there do some employment discrimination law. Most large firms have 2 or 3 lawyers who are dealing with that. And we know that ever since 1972 in Griggs versus Duke Power, the employment discrimination law has been interpreted to include what you said, Anthony, a disparate impact theory as well as an intentional discrimination theory. The lower courts with respect to housing generally went along with that. The Supreme Court, as you say, didn't get to it under the housing law until about 5 years ago in a close vote, but the majority ruled that the Fair Housing Act, like the employment discrimination law, has a disparate impact theory as well as an intentional discrimination theory. My own view, and then I'll turn it over to the other guys, is that although it was important not to lose that tool, particularly things like exclusionary zoning cases that Ed mentioned, and so it was an important positive decision in that regard. The vast majority of housing cases are intentional discrimination cases. What you need for a disparate impact theory of liability is you need an across-the-board policy by a housing provider. You get that a lot in employment. You get that less so in housing. There are landlord screening devices, like we won't take anyone with a criminal record, that I think are susceptible to being challenged under a disparate impact theory. But those are tough cases. You have to assemble statistics, and it is, in my view, that the key to fair housing cases is still intentional discrimination cases.
Yeah, I wouldn't disagree with that. We do see on disparate impact, a criminal record is a good place where a landlord might have no misdemeanors for the past 40 years. Clearly, that's not something, and the real key to the disparate impact is because you can defeat it if you have a real business reason. And if a landlord has a real business reason, they're probably going to be able to get away with that. And if you had a policy, nobody who committed arson within the last year can rent here, you're going to be able to make those 2 links, and that's going to make business sense for the landlord. But if you have no marijuana possession for 40 years, it's probably not going to be anything connected to whether or not that person be a good tenant. So we will still do those cases, but again, that's a small portion.
Well, the other place that maybe, I've lost you guys. Can you hear me?
Yeah.
Yeah, I've lost the picture, but the other place where maybe a disparate impact is income guidelines, that they won't take Section 8 or vouchers or anything like that. But like Professor Schwemm said, the courts are pretty clear in the employment setting that for disparate impact, you need to show statistical proof. And that sometimes is very hard to come by, and very expensive to come by for a solo practitioner, or even to get the money for a local commission to do it. So I believe most of the cases are intentional. And correct me if I'm wrong, I believe if you have a fair housing violation, you don't have to prove the intent to violate the Fair Housing Act. Is that right? Am I wrong on that? you can show
A couple of different provisions, Ed.
Yeah.
The one you may be referring to is the advertising provision,
the advertise. I'm sorry.
which makes any kind of advertising that indicates, that's the key word, indicates discrimination illegal. So even if a person said, well, I put a bunch of white human models in my brochure for my apartment complex, I didn't even know what I was doing, I wasn't intending to discriminate,
Right.
that can be a violation. But if you turn somebody down, and that person says, you turned me down because of my race, I think you have to prove as a plaintiff in that case that they intentionally discriminated. Now, sometimes, Anthony, there's an overlap between these theories. And let's take the example of a apartment complex that either has a no criminal background of any kind record, or I don't rent to people on Section 8. I mean, one way to challenge that, because it doesn't explicitly talk about race, is disparate impact. But another way to challenge that is to just say, I think you did that because you knew you couldn't say race, and you were just using that to intentionally discriminate on the basis of race in kind of a smokescreen. And it's always been true in the law that a person can prove intentional discrimination by at least starting out by showing that a defendant had a policy, knew it was going to disproportionately exclude African Americans, and continued to do it. In a way, as Art said, if you don't have a good reason, you'll lose under the disparate impact case. But I think in an intent case, you'd probably lose also. I mean, why are you continuing to use this policy that you know disproportionately excludes blacks if you don't have any reason for it? That's an intent case.
So along those lines, kind of talking a little bit about landlord-tenant issues, and housing as well. But you know, we talked about these, I guess, qualifying standards or requirements that a lot of particularly landlords use on prospective renters, screening tools. I mean, is there any way that we can make sure that these screening tools are being performed kind of uniformly, and that, for example, they're not just doing credit checks for, you know, African American tenants as opposed to other tenants, or vice versa? I mean, are there any way to make sure that these same qualifying standards are being used on all prospective renters?
So at my office at the Fair Housing Council, we do employee testers. So we will send out black or white, female, male, and we'll test just to see if people are being treated different based on their protected status. We'll see whether or not the policies are being done uniformly. Complaints filed with the commission. The commission has that power to investigate as well, pull records, subpoena stuff, just to see whether or not those are done uniformly. And those are the kind of things you're getting at, Anthony, where individuals, that's where there's that person who says, I don't want to rent to blacks. That's number one. I think there's less of that person. I think we have tools in our toolbox to get that. There's also that person who doesn't know it's in the back of their head, right? Like I'll rent to the old black grandma, but I'm not going to rent to the young black male. But I might rent to the young white male, right? Like it is just it's some implicit bias that they might not even be aware of. But those are the things that we will do, conduct testing. There are investigative aspects where we can pull some of that out.
There's a case out of Virginia about 3 or 4 years ago where the landlord screening device was, you have to be an American citizen, or you have to have some evidence of being in the country with the proper documentation. And it turned out the people who wanted to challenge that did it in 2 different ways, and ultimately were successful. One was, as Art suggested, they said, well, are you really enforcing that against people who look like they've come from England? You know, so they would send out a tester who said, well, I'm over here on a green card from England, but and obviously if the result was that the test showed that the landlord, were enforcing this policy aggressively against racial minorities, but not against whites, that's an intent case, that's illegal. even if the landlord sort of passed that test and said, no, we apply this across the board. Well, that's where the impact theory comes in. But I think it's always important to have testing to show what maybe you don't even need the impact theory. Maybe you've got intentional discrimination. And that goes back to the difficulty of filing a case. Picture an individual who's just moved to Lexington who needs an apartment complex for him and his family, or her and her family, because they're starting work next week. So it's hard to find a place. So they go around and let's just say the first place turns them down. Well, they're not going to stop and call up Art Crosby or Ed Dove or something like that. They're going to get on to the second place because they got to move in. It's a law that almost entirely relies on victims for its enforcement, and being a victim of housing discrimination is very hard to stop your life and say, gee, I got to find a tester. There are cases. I mean, there are people who call up their white friends and say, I think there's something phony going on out there. Would you go out and pretend to be like me? And then the landlord does look pretty stupid. But it's a hard law to enforce if you don't have the resources of someone like Art or Ed right at your shoulder at that particular time.
And I'll just briefly discuss the Uniform Residential Landlord-Tenant Act and how it plays out with Kentucky and Kentucky law and its effect in Kentucky. And I'll throw that out to whoever wants to answer.
Well, okay. I've done a lot of landlord-tenant law, and I know you all will probably be surprised. I even looked up ERLTA and see how many jurisdictions have adopted the Uniform Landlord-Tenant Act, and I was really kind of surprised because I found out that Georgetown, not Scott County, but Georgetown has adopted the Uniform Landlord-Tenant Act. But the Uniform Landlord-Tenant Act is not a statewide system or a body of statutes. It is in local jurisdictions, and at this point, 116 counties have not adopted the Landlord-Tenant Act. But the Uniform Landlord-Tenant Act, I think it tries to strike a balance between the rights of the tenants and the rights of the landlord. But it does give a tenant much more say and more rights in their residential or their lease agreement with a landlord. Years ago, there was a case argued by Robert Smith. I imagine Professor Schwemm knows Robert Smith, but it was called Miles versus Shawnee. And in Miles versus Shawnee, the Louisville Legal Aid, it was a case that the tenant had rented a house that was substandard. The house basically, they moved out. I can't remember the exact facts, but due to the fact that we have no warranty of habitability in Kentucky, they were kind of creative in trying to use the Kentucky Consumer Protection Act to prove that it was a consumer right to rent an adequate housing. Miles versus Shawnee was not, the court did not agree. So Kentucky has, in most of our counties, have no warranty of habitability. I hate to get into a story, but when I was in Western Kentucky Legal Services in McCracken County, a young child walked out, porch door swung, slammed. The porch fell on the child and killed the child. No recourse against a landlord by the tenants. So we still have this archaic provision in most counties that there is no warranty of habitability. So under the Uniform Landlord-Tenant Act, which is available to tenants in certain counties, mostly Jefferson, Fayette, Northern Kentucky. I think Warren has it, and obviously Georgetown now. It does give the tenant a right of retaliation, to assert a retaliation if they have reported a code violation. It gives the tenant a right to adequate housing, adequate heating, ventilation, water. It also gives the tenant a right to submit a 14-day notice for an opportunity for the landlord to cure. It also requires a landlord, if they want to terminate the lease, to provide adequate notice to the tenant. One provision that's not under the Uniform Landlord-Tenant Act that many people do not know, which is under the other provisions of 383, is a jury trial. If a tenant is given proper notice, an enforceable detainer action, that tenant has a right to ask for a jury trial. A lot of tenants do not do that. One, because the jury trial, one, they don't know. Two, they have, they don't have a counsel. And three, there's been a recent example here in Fayette County where an attorney asks for the judge for a jury trial for his tenant, and the judge refused. So it's a statutory right a tenant has, either in an ERLTA county or a jurisdiction, or in just any non-ERLTA, to have a right to have a jury trial. The only other thing in a non-ERLTA area that a tenant has a right to is a 30-day written notice. Okay, so when you look at the balance between what a tenant a landlord is required to provide for a tenant under ERLTA versus the other jurisdictions, non-ERLTA jurisdictions, ERLTA is good for tenants, but it also has a sword there for landlords if a tenant does not comply. For example, you do not pay the rent, landlord can move with a 7-day notice. Non-ERLTA jurisdictions, you don't pay the rent, it's a 30-day notice. So there's give and take, but I would prefer to live in an ERLTA jurisdiction as opposed to a non-ERLTA jurisdiction because of the provisions. I don't know if that answered it or not. But.
I'll follow up real quick, just a couple of quick points. One, your ERLTA is slightly better. Two, I don't know why your ERLTA is not statewide at this point. To Ed's point about Georgetown, there's a mobile home park in Georgetown that's part in Georgetown and part in Scott County. It's the same mobile home park. Part of it's covered by your ERLTA and part isn't. So right. Even within the same mobile home park, we enforce different laws. And then third, I think even in your ERLTA, and just taking this opportunity to talk about the systemic racism that we see in the eviction court, right? The idea is we know that disproportionately blacks rent, especially in Lexington. We know home ownership is disproportionately white, rental is disproportionately black. We know eviction court is run very different than foreclosures. We know that in eviction court, you're gonna get about a minute. Sometimes, like there's literally 55 people scheduled for a 60-minute trial or court period. And in that time, you're not going to really have an opportunity to make a case. It is a very quick, a systemic way of moving people out. We know that it's going to be mostly black people showing up to be evicted, and it's going to be mostly white people showing up to do the evictions. And we know that we just perceive things differently for renters than we do for homeowners, for home renters than we do from homeowners. I had this conversation with another attorney. They're like, why doesn't the tenant just move out? I say, because it's their home. The attorney says, well, it's not really their home. It's not like our home where we go. And they're like, it is their home. That is where they live. The fact that you're renting the home versus, in my situation, paying a mortgage company for my home doesn't really change the equation that much. But we evaluate somebody who is down on their luck and not able to pay their mortgage as somebody much more worthy of like, well, that's unfortunate. Whereas somebody who is down on their luck and hasn't paid their rent, it's like, well, they just need to move on.
Yeah, if you look.
Go ahead, Ed.
Oh, I was just going to say this is kind of an old study that was put out in 2014, but it just gives you an idea that, to follow up what Art said, is that the majority of tenants who are evicted are minorities. The Lexington and Fayette County has combined total of 6,199 Section 8 and public housing units. Council districts 1 and 8 have the greatest percentage of these units at 19%, followed by Council District 11 with 15%, and Council District 2 at 12%. 5 council districts, 1, 2, 4, and 8, and 11 contain 3/4 or 76% of Section 8 and public housing units. So it gets kind of like at the beginning of what we talked about, the geographic picture of Fayette County and where people of color and people of lower income live is concentrated in certain districts. And that means a lot of these evictions are coming out of those certain districts. And it's like Art said, it's really frustrating to go and sit in forcible detainer court and watch people stand up. And I'm not saying every one of them has a defense. I'm not saying that. I think there's before pre-COVID, I think it was a real hard time to defend a failure to pay rent if you're getting 30%, a third or 30% of your income. I mean, unless some of these circumstances. But there are other issues, material non-compliance. Like right now, I'm defending an eviction. A material non-compliance is the landlord's alleging that my schizophrenic client licked her fingers and rubbed the elevator buttons, which caused a health and safety hazard. So that's material non-compliance. They're moving to evict her. And she's disabled. She's not an African American, but she is disabled. Forcible detainer court. I'm sorry, Professor Schwemm, but it's a lost area. It's a lost area of legal rights for tenants, and it gets back to I guess my theme is the education. How do we educate these people?
The only point I want to make is about the disproportionate number who are African American who are being evicted. So now you've got an eviction record. And what I believe is happening nationwide, and I wouldn't be surprised if it was happening here, is that more and more landlords, when it comes to screening devices like we talked about before, don't do the background themselves. They hire somebody who's online. And the online people say, oh, we can tell you whether so-and-so's got an eviction record or got a criminal record. And sometimes the data is awful. But even if it's accurate, if a landlord adopts a policy now that says, I will not rent anyone who has an eviction in the last 5 years, you just have heard that that will have a disproportionate negative impact on African Americans, probably a disproportionate negative impact on females as well. How many people who get turned down for an apartment are going to be able to marshal the resources to bring a disparate impact against that landlord? Not unless you've got some super help somewhere. But at least the theory of the law is landlords, you can't do that unless you have a good reason. Now, the response will be, well, we want to make sure people pay the rent. And then you get back to Ed's point. Well, but that's too broad a brush to this person maybe didn't pay the rent one time because of COVID. You just can't have that across the board policy, or you're going to wipe out a huge number of potential tenants who are Black or female.
You also,
I think you have to even take the bigger picture of why do we have disproportionately so many more African American renters? I mean, it wouldn't be that, none of this would be a big deal if it was affecting everybody across the board equally, right? The fact of the matter is we just know these things impact Blacks more because we have created a society where Blacks are going to be our renters, and therefore we're just not as worried about that impact.
well, you look at even HUD has a policy about prior drug convictions, drug use of the individual tenant or family members. as not being eligible to get into housing or could be evicted for that sort of activity. We've seen cases at the commission where women were victims of domestic violence and the landlord has moved to evict them because the police came out too often. So I mean, it's just a huge issue that doesn't get a lot of attention, I don't think.
And Herb Miller has a comment. Beginning in the 1970s, the Federal Community Reinvestment Act required federally insured banks to create programs and policies to make credit, particularly for home mortgages, more available for groups who had been previously denied. However, the act allowed credit to be denied on individual cases for reasons such as bad credit, no credit, poor housing stock, low net worth, and land title problems frequently seen in older, low-income neighborhoods. So well-intended mortgage loan officers were still able to make loan decisions based on traditional standards of credit. Looking back, I now see that the act failed to address the systemic and historical issues flowing from the national policies covered previously by the speakers.
Yeah, I think that just gets to my point of once you've skewed the game board so much, you can now say, well, we're going to play by the right rules moving forward, and you're still going to have the same impact.
There has been cases that have been brought under the Community Reinvestment Act where are the banks living up to their obligations? But once again, you get into a lot of that being a more disparate impact, which, as Professor Schwemm said, they're difficult cases.
I want to just briefly touch on, we obviously know there's going to be a change in the court, a new justice at some point. What is your all's thoughts on, I don't know, one, if there are any cases in the pipe regarding fair housing and the makeup of the potential new justice to the Supreme Court? Do you think that that's going to have any impact on Fair Housing Act or cases coming up down the pipe?
Well, I'll just give a little background. I mean, there haven't been that many Supreme Court Fair Housing Act cases, but in general, the court's been good to the Fair Housing Act. It used to be good to the Fair Housing Act 9-0. Recently, it's been good to the Fair Housing Act 5-4. In the disparate impact decision we talked about from 2015, that was a 5-person majority led by Justice Kennedy, who's now off the bench. So I suppose theoretically, depending on how radical the new appointees want to act, they could go back and revisit that. But because it's an interpretation of statute, I don't think that particular thing will be changed. What I think is the major drama is at the Court of Appeals level, because the last 4 years have put in judges at the Court of Appeals level that are about 40% now occupying those positions. And you can see in, say, the application of the Fair Housing Act's disparate impact that virtually anyone appointed in the last 4 years has given a very, very limited negative reading of the law. So the Supreme Court can't do everything. And it's probably true that more and more cases will be shifted to state court. I think it's up to individual lawyers like Art and Ed to figure out where the best forum is, but I don't see any immediate threat to the Fair Housing Act in the Supreme Court.
I think what you're going to have is the court will move more and more to this idea of everything needs to be colorblind, without any thought toward undoing historic legacy of discrimination. And I think that brings me back to that point of the director of the New Albany Housing Authority, where you've already got this crux and all people are in white in the one building and all people in black in the other building, and how do you fix it? And I think the Supreme Court will now say, well, there's nothing you can do to affirmatively fix that. You're just going to have to live with the result.
Well, we have about 15 minutes left, so I kind of wanted to circle back around to something Professor Schwemm had brought up earlier in the discussion, and that was obviously COVID-19. So I just wanted to briefly talk about in your all's opinion, do you think COVID-19 has exacerbated the racial divide in housing or impacted it in any way? And if so, how?
I'll start with that one again too. So we're doing part of 20 organizations here in Lexington who have created a COVID-19 Help.org website where we take in intakes from people who are having that difficulty and trying to figure out how to prevent evictions. And we know of those 3,000 or so intakes we've taken in, about 44, 45% of them self-identify as Black. And we know Lexington's about 14% of the population is Black, so it's a much greater impact, right? 44% of the people there who are needing and desperate help, trying to avoid eviction, are Black. And we know, like, as this plays out, those people are more likely to have lost their jobs, more likely not to be able to work remotely. We know that the discrepancies were already there. We know that COVID has just accentuated all the problems that already existed. You know, people like me who had mutual funds that temporarily went down, the stock market's back up, and my family's doing pretty well. But we know that the client base that I work with, that's just not true. They haven't worked for a while. Their jobs that they had might not come back. They are already 4 or 5 months behind. They've cashed in whatever savings they had, and their life's not going to get any easier for the next few months. So those discrepancies will continue.
Well, I think it's like Art said, these people are behind in their rent, and he said the numbers. But what we did talk about is if a tenant is found to be guilty of the forcible detainer, and they have that 7 days to vacate, they also have 7 days to appeal. But the problem with an appeal is if you read the statute says that you have to place all rent that is owed plus pay current rent with the court to perfect your appeal. And if someone's $5,000 behind because of COVID, obviously that's not going to happen. So we got a conflict because the Constitution of Kentucky gives you the right to one appeal, but yet not having the income because they're not working will deprive them of that right to appeal to the decision of the court to grant the forcible detainer, and they'll be out in the street in 7 days. It's just a horrible situation.
COVID is just another example of what we've been talking about, which is an overlay of a problem on a system that is already stacked heavily against residents in racially impacted and poor neighborhoods. And it, I guess, came as a surprise to some white Americans that COVID disproportionately harms minorities, but it certainly doesn't come as a surprise to any of us who are in this field. And it should never have come as a surprise to any sensitive person. Down the road, when we get through hopefully when we get through the immediate impact of COVID, there'll be some professorially interesting issues that are minor in my judgment, like whether a landlord can ask you if you've had COVID, or whether you have the kind of job that puts you in a first responder, hospital, or bus driver kind of situation. Bob Schwemm will be interested in those, but those are minor compared to the dramas that Art and Ed are talking about day in and day out. And the impact of almost any problem you can imagine is disproportionately visited on the poor and the minorities in this country.
And Professor Schwemm mentioned earlier the education tie-ins and how housing connects to everything. I think that's the other layover in terms of where we're going to look at the COVID impact. Where you live impacts where you go to school. For example, the difference between Cassidy Elementary and William Wells Brown. You know, William Wells Brown, 72% African-American, Cassidy, 74% white. The test scores in those two schools aren't anywhere near the same. And we know that COVID's not going to impact those two schools the same either. We know that William Wells Brown parents more likely to have, you're not going to have a stay-at-home parent necessarily. You're going to have children with little or unreliable internet access. You're going to have children with food issues, food insecurity. Their ability to achieve and continue to do well in that environment are going to be very different than those at Cassidy. And all that's based on where you live.
So we have about well under 10 minutes left, so I just kind of wanted to wrap up with allowing each of you all to kind of, just in summation, talk about what you all suggest or think are some positive steps, and I think Professor Schwemm talked about this a little bit already earlier, in trying to tackle the issue of housing discrimination, and any suggestions that you might have from your all's perspectives on things that can be implemented or things that can be done to help monitor and help stop these practices.
Okay, I'll go first. So this shows both my optimism and my pessimism, and how it's just a very nuanced. Anybody who says there's this one thing that does it and fixes it, I think just does not have a comprehension of the issues we're looking at. But the City of Lexington puts about $2 million every year into Affordable Housing Trust Fund. And in that money, we're using to create affordable housing opportunities for people and build new properties. The question about where you put that affordable housing looms large. And there are competing interests both ways. So if I put that $2 million in to Winburn area, I can build 15, 20 homes. But if I put all my affordable housing in the area that's already disproportionately Black and has, from systemic racism in the past, a legacy of that, I'm not only not stopping the legacy of discrimination, I'm adding to it, I'm increasing that burden. But if I take that $2 million and build one home next to John Calipari's place for affordable housing, right? Well, then I can put one person in there versus over here I had 15, and we know we need more housing. So you're caught with the idea of, do we just build more affordable housing because we need more affordable housing, or do we build more housing in areas that have what my friends look for when they're looking for a house, education, employment, safety, crime, all those things. And I think those are two competing interests that you can't just say one wins over the other. But I do think the city, and I think the city does try its best in Lexington to do this, you are supposed to at least be aware and try to have that thought process of, how do I balance those issues? How do I balance the need for more housing versus where do we put the affordable housing?
I would agree with that. I think the number one issue is affordable housing. We have a national housing crisis in terms of what people are spending or what people are required to spend on housing. It's never been so high. And most of the new housing that's being built is not affordable to the average person. This is the book I mentioned earlier. This is called Moving Toward Integration. It's a long academic book, but it's a valuable book in the sense that they do have ideas that any lawyer can access, and affordable housing and strategies for getting affordable housing built and somewhat scattered is crucial to that. Think about the phrase affordable housing. I mean, there's some people who obviously have been taught to recoil about it, but break it down. If someone said to you, well, this is an affordable restaurant, or this is an affordable car dealership, that would be a positive, right? The word affordable is a positive thing. So what is affordable housing? Why do people begin to think, ooh, that's a problematic, that's a social experiment? It's the word housing. And that means where people live. And as a society, this goes back to our original point, I have hopes for the future. But it just takes attitudinal change so that people can say, we are a country. We are bound to each other, regardless of our race or our gender or our national origin. And we need to do things that make life good for all of us. Won't happen tomorrow, but we need to move in that direction.
I guess I would end up with a more immediate need. I mean, I certainly echo the feelings about the affordable housing, but I think the more immediate need is for more advocacy in the landlord-tenant eviction courts. Obviously, we show that the tenants that usually are evicted, many are for failure to pay rent, so they don't have money to hire counsel. We look to the Legal Aid Society, Legal Aid Bluegrass to take that representation of tenants. Obviously, they can't take everybody. And I think everyone loves having a house. I mean, whether it's a rental or it's your house. And I don't think that they understand that when the person is in the enforceable detainer court, that they're 7 days from the street. And homeless services in Fayette County are not the greatest. And as Professor Schwemm said, if you have an eviction on your record, it's very difficult to get in to public housing or into private housing with that. So we're talking about the trickle-down effect of being evicted, and not everybody has a defense. But I think we just need to get some more advocacy immediately to help these tenants in eviction court from being saved or from being forced onto the street within 7 days after their court appearance. And I don't know.
Ed, let me ask you a follow-up question of that. We've got people in our audience who might be moved by what you've said or what we've all said. If there were an additional 20 or 30 Fayette County lawyers who wanted to volunteer to help tenants in these situations, how would they be used? How could you, Ed Dove, tell them what to do?
Oh, I wouldn't tell him what to do. I would refer him to Josh Fain at Legal Aid of the Bluegrass. He in the local bar, recent bar, he put out a request for people to step up and represent some of these tenants. But I was a legal service attorney for many years, doing housing, and we never had enough money to hire enough attorneys. But it's I just suggest you go down there to forcible detainer court one day, and you really would be surprised if you saw an attorney representing a tenant. I mean, it's not lucrative. It's just, I mean, private counsel can't afford to represent someone who can't pay them. I mean, it's the bottom line. And there's no resources to pay them, such as in the dependency neglect situation. Whereas you've got a few handful of landlord attorneys that are being paid nicely to put them on the street, which I'm not condemning, but it's tough.
And I think we'd be remiss if we didn't address the fact that we're three white men talking about racial issues, three white attorneys, and that the attorney system as a whole tends to skew white and male. And I think if we're talking about representation of legal rights, as long as that holds true, that's going to be an impediment as well.
Okay.
That's true. Well, I appreciate everyone's time on this panel. This has been a very enlightening discussion. And I really am optimistic on some of these ways to tackle these challenges that we have ahead of us with these issues. So with that, I guess I'll turn it back over to Caitlin. I don't know if there's any other logistical things that need to be done here before we wrap up.
That's all I have. Thank you all so much for this panel. It was really great, really informative. For the attendees, the CLE sheet is on the website. If you have any issues, just reach out to us at the Bar Association. Thank you all again. I really appreciate it.
Thank you.